Namaste and greetings. I, Shweta Shankar, researcher at IMPRI, Impact and Policy Research Institute, Prabhav Evam Niti Anusandhan Sansthan, Nai Delhi, extend my warmest welcome to you all to IMPRI #Web Policy Learning. Today, we are gathered here for day 5 of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course, and internship program. This program is organized by the IMPRI, Impact and Policy Research Institute, New Delhi. At the very outset, let me give you a brief background on this certification course. LPPYF aims to instill the understanding and skills pertaining to law and public policy. The thematic issues covered under this course are the paradigm of international provisions, constitutional laws, sustainable development goals, gender justice, environmental crisis and regulations, international human rights, and so on. The chair for the program is Professor Vibhuti Patel, visiting distinguished professor at IMPRI, and the fellowship lead advisor and the expert legal hands-on session is Advocate Dr. Shalu Nigam, visiting senior fellow, IMPRI. The distinguished experts includes Shri Sandeep Chachra, Professor Vibhuti Patel, Advocate Dr. Shalu Nigam, Advocate Dr. Wahida Nayanar, Professor Mukul Ashar, Professor Uday Shankar, Shri Udit Mishra, Dr. Nivedita P. Haran, Dr. Purnima Chauhan, Shri Bhartinder Singh Baswan, Advocate Dr. Albertina Almeida, Dr. Gladstone Xavier, Professor Aruna Roy, Advocate Audrey D. Mello, Dr. Kaustubh K. Bandyopadhyay, Advocate Mrinalini Deshmukh, Professor Sharmila Ghuge, Advocate Flavia Agnes, Dr. Rashmi Singh, Mr. Debaditya Sinha, Professor Swaran Singh, Advocate Lara Jasani, Professor Anil K. Gupta, Justice Ajit K. Singh, Mr. Himanshu Shekhar, Dr. Amar Jasani, Dr. Soumyadip Chattopadhyay, Mr. Bilal Khan, Shri Rajiv Ranjan Singh, Shri Tikender Singh Panwar, Shri Shailesh Gandhi, Advocate Abdul Hafiz Gandhi, Professor Amita Singh, Dr. Ajay Gudavarti, Shri Amit Dubey, Professor Sangamitra Acharya, Dr. Y. Suresh Reddy, Advocate Sanchita Ayan, Shri Surendranath Tripathi. The conveners for this course are Dr. Simi Mehta, CEO and Editorial Director at IMPRI, Advocate Dr. Shalu Nigam, Visiting Senior Fellow IMPRI, and Dr. Arjun Kumar, Director at IMPRI. I welcome you all to this enlightening deliberation and thank you for putting your time, energy, and efforts into truly understanding the vital role and complex intricacies of legal and public policy frameworks. The course will enable the participants to comprehend the nuances and technicalities of legal and public policy paradigms and therefore acquire theoretical insights along with technical skills to conduct research. We have also shared the course outline and reading resources document in your email for your kind perusal. We will be providing videos of each session for flexible learning at your place and pace. Before we start today's session, I would like to announce the housekeeping rules. First, it is imperative that you join the meeting on time. Second, there will be a Q&A session after each presentation. Third, share your questions in the Q&A box and not in the chat box. Fourth, the questions must not be posted as an anonymous attendee. Fifth, ensure that your questions are precise. Sixth, refrain from making general comments in the question to save time. Our session for day 5 will cover topics of Basics of Public Interest Litigation in India by Advocate Dr. Shalu Nigam and Bureaucracy, Laws and Public Policy by Dr. Nivedita P. Haran. Start the session, we invite Professor Vibhuti ma'am for her opening chair remarks. Ma'am, over to you.
Thank you, Shweta Shankar, for this invitation and I think giving the housekeeping arrangement. I also thank the IMPRI team, Dr. Arjun Singh, Dr. Simi Mehta, Dr. Shalu Nigam, Ms. Shweta Shankar, Ms. Nivedita, and Satyam Tripathi for the teamwork. Welcome Dr. Nivedita Haran and the esteemed participants. The brief outline of day 4, because we began on 2012th, and the first week we had 3 lectures, and the second week the lecture was it was a day 4, where Professor Uday Shankar and Shri Udit Mishra they gave a presentation. The first one was on policy initiatives and role of Indian judiciary, in which Professor Uday Mishra Shankar spoke about two schools of thoughts, one school which believed in separation of power and the function. That means judiciary and executive should be separated. They should not meddle with each other's domain. And the second school of thought that believed that all institutions should do their duties assigned to them. And whenever there is a breach of duties, judiciary has a role to question illegality, and judiciary can interfere and correct this irregularity. He also gave example of Balco privatization of public sector enterprises, the question of so many other social and economic issues he spoke about, and he also talked about the role of judiciary in terms of checks and balances that they have to manage. He also opined on the question of collegium, and he says that independence of judiciary is very important. And whenever the state is an litigant at that time, where the question of about the prisoners languishing, Dr. Shalu Nigam asked about this whole judicial delay. About that also, he said that what we need is that very important. We need more infrastructure. And so many trivial issues in which court's time goes. I think they should also be dealt with in a very different way. And he also spoke about the more and more structures and mechanisms that make both judiciary and executive accountable, which is very important. Dr. Udit Mishra also talked about the Dr. Udit Mishra spoke about the law, public policy, and media. And he said that introduction of artificial intelligence is going to change the whole discourse and whole dynamics of the media reporting. And he gave so many examples based on his personal ground level work, where there was a field-based reporting. And he says the role of journalism is to bring out truth, and your opinion may be whatever, but truth has to prevail. He also gave so many examples of reportage about drought, which is a political issue, and a lot of things are involved in it in terms of electoral dynamics, no? And he also talked about the question of the best ideal model for media reporting without political interference would be that of a BBC, where the taxpayers are supporting the media house, and also it can be the public support, where the trust-based model, where the Guardian is supported by the trust, or the Tribune in Chandigarh is supported by trust. He also said that media is not a rocket science, and even with the commitment and genuine interest in the subject, in journalism or media reporting has a place, and there is a need for a committed and honest people in the media houses. So I think this was a very illuminating session where we talked about a lot of new things that are happening, and the challenge which is posed by the social media. I think about that also. He said that now journalists don't go to the field, but they just depend on whatever the public is. And public can also be very, very polarized, no? Because you may have a very polarized opinion on so many things which is happening currently in the world, in all other countries as well as in our country. So I think in a nutshell, this has been the unfolding of last 5 days of this course. Thank you.
Thank you so much, ma'am. Advocate Dr. Shalu Nigam, Visiting Senior Fellow IMPRI, Advocate, Author, and Researcher, Gender and Human Rights. Now I would request Advocate Dr. Shalu Nigam, ma'am, to start her session on basics of public interest litigation in India. Ma'am, over to you.
Thank you so much. Just share this presentation. Yeah, so we have been talking about public interest litigation in past year, for past week. So I thought maybe we can have this session about the basics, how to file and what is being done. So public interest litigation is known by several names, such as social action litigation, social interest litigation, class action litigation, and So in simple word, it means that litigation is filed in a court of law for the protection of public interest. And this public interest may include issues such as pollution, road safety, construction hazards, and so on. So public interest litigation is basically not defined anywhere in the law, but it has been interpreted by the judges to consider the intent of public at large. So the main focus over the years has been about violation of basic human rights of the poor, content or conduct of government policy, or you may compel municipal authorities to perform a public duty, or it may be about violation of basic fundamental rights. So such cases may occur when victim does not have the necessary resources to commence litigation, or they can't move to the court, because of various reasons. So the court can take itself, it can, take cognizance of the matter, or it can proceed on its own and, commence the petition, or any public spirited individual can file public interest litigation. So it is the power of the courts, it emerged because of judicial activism and public interest. How do you define public interest? In several of the judgments, they have defined public interest as something in which the public, the community, or the legal rights or liability of the public is being affected. So it does not mean anything so narrow, which is, the court says that it's a mere curiosity or the interest of particular localities or communities. It should be the larger question, and which should relate to the interest of citizens, generally in affair of local, state, or national government. So Justice P.N. Bhagwati, in one of the cases, he says that the court has to innovate new methods and strategies to provide access to justice to large masses of people who are denied basic human rights, or to whom freedom and liberties have no meaning. So therefore, they have evolved. It has been evolved in India because of judicial activism and because of civil society initiatives, so because in law it is not yet defined. Basically, if we go look at the history in brief, we see that it started in USA, where in USA they have filed litigation regarding environment, consumer, or about racism issues and ethnic minorities issues. So started in 1960s around USA, but in India it gained more importance after emergency. Like emergency arose during 1975-77, where state repression was huge, and thousands of innocent people and political opponents were sent to jail, and there was complete deprivation of civil and political rights. So the post-emergency period provided an occasion for the judges of the Supreme Court to provide access to justice to the poor. In post-emergency, Supreme Court tackled the problem of access to justice by people through radical changes and alteration made in the requirement of locus standi, or that means any of the party agreed. Now, this is a splendid efforts being made by Justice P.N. Bhagwati and Justice B.R. Krishna Iyer, who have both these judges. They have played an instrumental role in revolution of this concept, and they say that we can provide justice to poor and exploited people by relaxing the rule of that only the aggrieved person can file the case. So and at that point of time, investigative journalism was also beginning, and they were exposing that how there is lawlessness is there, repression is there, custodial violence cases where at that point of time, there was a lot of those cases were there, and a lot of lawyers, judges, and social activists. They play a very proactive role, and this is something which is very different from traditional justice delivery system, and where judiciary is performing a very proactive role. So what is locus standi? Like prior to 1980s, only the aggrieved parties could personally knock the door of the court and seek remedy for the grievances. And any other person who is not affected personally could not go to the court and say that, okay, this case has happened. And so, so there was hardly any linkages, because a lot of people were, if people are poor and illiterate, they cannot go to the court directly. So, and if you don't know your rights, you can't go to the court. So this concept of locus standi is quite limiting. But over the years, the courts have expanded this concept in the cases of public interest litigation. So, so right now, and basically they have done this under Article 39 of the Indian Constitution. Article 39 is, if you remember, we have seen that it provides for free legal aid, and it provides that the justice should be promoted. So so therefore the courts have expanded this notion during in the cases of PIL. So basically filing a PIL is not a cumbersome or as a usual legal case. And there have been instances where letters and telegrams addressed to the courts have been heard as, as a petition. So public interest litigation gives a wide description to the right to equality, right to life, and which are guaranteed in Part 3 of the Constitution of India. And it has functioned as an effective instrument to bring about social change. And now any public spirited person can seek remedy on behalf of the oppressed classes. If you remember, we have spoken about Article 32 and 226 in the Constitution of India, which talks about writs. We have spoken about this writs earlier, but basically these writs are filed under Article 32 of the Constitution or Article 226 before the High Court. 32 is before the Supreme Court. So only the affected person could go and file the writs. But when the judiciary expanded this concept of PIL, so now anyone can go and file this public interest litigation if all these rights are violated. So so it's basically a focus is laid on litigants and their rights. And at present, a court has power to treat a letter as a petition and take action upon it. In various cases, the court says that the letter could be treated as petition only when the letter is addressed by an aggrieved person or a public spirited individual or a social action group for enforcement of constitutional legal rights. For a person who is in custody, or it could be a class action claim because many of the people could not come to the court because of the reasons of poverty, disability, or any other disadvantages. So Justice P. Bhagwati, in one of the case, he has elaborated like what are the essentials of public interest litigation. So he says that only a lead party must be the victim of legal wrongdoing, and that is punishable. And so this victim must be in a position when he or she is unable to contact the court for various reasons. And if all the conditions are met, any public representative or member may file a complaint on behalf of the victim, and the court must ensure that PIL is in the public interest or for greater good, rather than for victim's personal benefit. And if all these conditions are met, any letter can be treated as PIL. So what are the procedures for filing a PIL? If you are filing PIL, the basic important thing is that you should do a lot of research. You must make informed decision to file a case. Consult all the affected interest groups who could be possible allies. Be careful in filing a case because litigation can be expensive and time consuming, and it can have an adverse decision, and it can affect the strength of the social movement. So if you have taken the decision that you will file PIL, then you have to collect all the relevant information, have to be very meticulous in gathering the details. Because if you remember, like there was a case of Olga Tellis, and I attended some of the brief, like the briefings conducted by Indra Jay Singh and Nandita Haksar and all those senior lawyers. And what they have said is that while filing the case of for the rights for the pavement dwellers. They have really gone into the details of, the food basket. The food basket, we'll discuss about this case later, but then basically food basket means, if a person is earning X amount of money, and if person is going to, if you are displacing this person to some other place, and then if in X amount he is buying ABCD, kind of items on his food plate, and if you are shifting this person to another place, in that case, he may not be able to afford all the ABCD 4 items in his food plate. So, those kind of research, they have also gone into that kind of details. So basically, you have to conduct a lot of research. So a PIL can be filed by any registered organization, and or it could be filed in the name of office bearer or member, or in his or her personal capacity. So otherwise, you have to issue a legal notice to the concerned party, and if you are filing a suit against the government, you have to issue notice prior to 2 months of filing. And these cases are being filed in the same manner as writ petition, and it could be filed in High Court or the Supreme Court, and the copy, the court rules that number of copies have to be filed, and an advance copy has to be served to each of the respondent. And then there is a procedure of, affixing the fees, and, all those kind of details are there. And during the PIL, the judges can reject the PIL, they can accept your petition, and they can, if they feel, they can appoint the commissioner, as we have seen in Right to Food case, that, they have appointed commissioners, they have, they have appointed inspector to look into allegations of pollutions and, other kind of things. So generally what happened in the court is that the reply has to be filed by the opposite party, and then you can file rejoinder as a petitioner, and then final hearing can take place, and the judge can give us the final decision. So against whom you can file public interest litigation? You can file this litigation against, any public authorities. So public authorities means Government of India, any body, any local authorities, any municipalities, all these could be the parties, because generally it is the state bodies, the organs of the state against whom you file public interest litigation. But you can make a private person as a respondent. Say, for example, a private factory in Mumbai, if it's causing pollution, then a public interest litigation can be filed against the government, the state government of Mumbai, and the private factory could be made as respondent. So if you see over the years, PI has been successful in making official authorities accountable. It is about empowering citizens. It is used as a tool by the civil society to really, ask the government, to act properly, to protect the rights of the citizens. It has dealt with the cases of environmental grievances, socioeconomic rights, civil and political rights. As we have seen also the Vishaka judgment, which has been evolved because of public interest litigation filed in the case of Vishaka versus state of Rajasthan. So in one of the case, Justice Singhvi and Justice Ganguly, they pointed out that laws enacted for achieving the goals set out in the preamble of the constitutions are inadequate. So it is a duty of judiciary to protect the right of every citizen and to ensure that all citizens live with dignity. And the courts could, they have the power to proceed on the basis of letters or newspaper report. And Professor Bakshi, Queen Bakshi has commented that, it is social action litigation has played a critical role in expanding the idea of citizenship for the poor people in India, and it has deepened the democracy, and so it has helped really to really, for the poor to really assert their rights. And at another place, he said that, after the emergency, because of catharsis, the judicial populism is being shown, and Supreme Court effectively, at the line of executive, and in the post-emergency period, during the period of 1980s, a lot of important cases have been filed and very important decisions have been given. But for example, this Sainara Khatun versus State of Bihar in December 1979, Kapila Hindorani, she was an advocate. She filed a petition about the condition of prisoners detained in Bihar jail. Cases were pending in the court, and this petition was signed by the prisoners of Bihar jail, and the case directly went to the Supreme Court, and the bench headed by Justice P.N. Bhagwati decided that prisoners should receive free legal aid, and their cases should be heard very quickly. And as a result, 40,000 prisoners were released from jail. In MC Mehta versus Union of India, the court shut down numerous industries and allow them to reopen only after that the pollution control things are being put in place, so that the Ganga basin is not being polluted. In another case, the court has passed orders against Mathura refineries for polluting ambient air around the Taj Mahal. In another case, the court has forced the vehicles in the capital to switch to a different fuel in order to keep check on vehicular pollution. And more recently, it's just this month only that this judgment has come out, where a PIL was filed in Odisha High Court, and it cites 11 children, 4 of whom were severely malnourished or they're acutely malnourished, and they were not covered under PDS or Food Security Act. And the court asked for the detailed response from the state, and they say that the schemes by the government should be inclusive, and because in that state, they found that 30,000 children were severely malnourished, and 86,000 children were acutely malnourished. And this is a kind of state of alarm. So just because they don't possess the Aadhaar card or a mobile phone or a proper identity paper, so the child and their family, they are being denied the basic support in terms of food and supplements. We have discussed this earlier also, that how, because the Aadhaar is not there, because the mobile phone is not there, or something, sometimes the things are not working. So these kind of things are happening, and the children are being denied food, and they're suffering. And the court says that the absence of these documents cannot become obstacles to availing the benefits under the scheme. So another case where in state of Bihar, the police brutalities were exposed through a newspaper report, which says that about 33 suspected criminals were blinded by the police in Bihar by putting the acid into the rice. And through the interim orders by the Supreme Court, it directed the state government to bring the blinded people to Delhi for medical treatment. And they ordered for speedy prosecution of guilty policemen. And they also provide free legal aid and says that it is a fundamental right of every accused. In yet another case, the court says that the handcuffs and fetters should not be forced upon our prisoners while they are lost in a jail or while in a transport or transit. In another case, a prisoner sent a telegram to a judge complaining about forced handcuff on him and demanded protection against humiliation and torture. The court gave necessary direction by relaxing the rule of locus standi. In another case, the custodial violence against women prisoners in Bombay, a letter was treated as a writ petition, and directions were given by the court. And in similar, I can go on and on about cases. And recently we have this Puttaswamy judgment, where court has held that right to privacy is essential to leading a life of dignity. So in several of the cases, the courts have given the directions in favor of litigants, in favor of poor, in favor of in another case in Agra protective home, women were treated in inhuman conditions, and the court says that this should not be done. The courts have also given, asked the medical doctors and, the hospitals that, they cannot say that during the time of emergency, they cannot deny treatment to the patients. So they have also helped to protect the tribal rights. In one of the case, the court held that industrial private companies and non-tribal people cannot access the land owned by tribals for mining or leasing purpose. The courts have also protected the right, in terms of child labor, ending child labor and Child Labor Prohibition and Regulation Act 1986 that focus on eradicating child labor and bonded labor emerged because of, activism which goes behind this case of Bandham Mukti Morcha versus Union of India. In terms of manual scavenging, in 2012. Now, there was a person called Rajan, and he died during manual scavenging, and Division Bench of Delhi High Court ordered the state to pay compensation, but the Delhi Jal Board filed an appeal against this order. Now, this appeal shows that how the state apparatus is insensitive to the safety and well-being of those who are, because of the sheer poverty, they're compelled to work under most unfavorable condition. And, so the court examined 3 questions. They say whether the High Court was justified in entertaining the petition filed by the Delhi Jal Board by the way of public interest litigation, whether the High Court directions about the amount of compensation are they right, and so the Supreme Court in this court has said that social action groups can take up the cases of poor people, and the state agencies cannot absolve themselves of the responsibilities to put a mechanism to ensure safety of workers employed for maintaining and feeding the sewage system. And the court says that compensation should be higher. So they quoted another case where Railway Board versus Chandramadas, where compensation was in 1998. They say that we have announced the compensation to be paid in terms of 10 lakhs to the victim of rape, though these cases are not equivalent, but then still, the High Court should have given at least proper compensation because this case is about the dignity of the citizens and rights of workers. But these are very good examples. But again, the courts have warned that frivolous public litigations, they won't be allowed. And petition, the person who is filing the petition must prove to the satisfaction of the court, that there is no frivolous lawsuit which is brought for monetary gains. The Chief Justice of India, the 38th Chief Justice, he said that fine should be imposed if litigant is filing frivolous litigation, and they have shown concern about the misuse of PIL. And in one of the case, the court says they have fined the petitioner with the fine of ₹1 lakh. And Balco cases has been discussed. And again, in Balco cases, the court has said that the Supreme Court has limited standing in public litigation, in the public interest litigation, and the court should impose exemplary cost if the frivolous petition is filed. So in several cases, the court had said that it can't be used as a weapon to be misused. So these are the cases where the court have laid the guidelines that how they will say that who can file the case, what is public interest litigation can go, which are the social organizations which can file public interest litigation. And this is the list of recent cases. This appeared in Outlook, and here the cases are listed where petitions are being dismissed and cost is being imposed. For example, one of the party has filed the case that center should construct a great wall along the entire border of country, and this petition was dismissed. Another case says that all repeal all pre-independence law because Parliament is hostage to colonial mindset, and this petition was dismissed, and the fine of rupees 1 lakh was imposed on the petitioner. So, so these are the kind of cases where the courts have imposed fine on litigants. A study which was conducted by the World Bank in 2009 shows that PIL constitute only 1% of the overall case load. So when people say that public interest litigations are being misused, we need to do a lot of research that, what kind of misuse, how many cases are being filed, and so on. So this study found that a very low share of the cases are brought about by cooperative entities such as NGOs, which is useful for the larger population. And the win rates in the cases of fundamental rights claims are now significantly lower when claimant is from lower disadvantaged group or from marginalized group. So, we have to do more studies to find out, if how this PIL can be used as a tool to demand accountability of the state and as a tool for efficient governance. So these are some of the citations I'll share with you. So thank you. With this, I will end my presentation. I'll stop here and maybe we can discuss about this.
Thank you so much, ma'am, for an enriching and such an insightful session. Now I request the chair, Professor Vibhuti ma'am, to share her remarks.
Yeah, thank you, Shweta. And Dr. Shalu Nigam has made a very important presentation on public interest litigation that enhances the democratic rights of the people. And she also gave a whole history of how Justice Krishna Iyer, Justice Bharwati gave some of the landmark judgments and the constitutional provision of Article 39, which also ensures free legal aid, and as a result of which we also have union budget for free legal aid. And they have a duty of doing the awareness about the existing laws. At the same time, those who can't afford the legal cost, they also need to be supported by this. But in most of the states, legal aid funds remain unutilized because there is no proactive force. And most of the time, legal aid center itself is a paper organization. You see the board, but they are not functioning. So I think how to make it is a citizen pressure that can make these centers more active. Alternatively, people have also come up with Lok Adalat, their own people's court, because they know that the existing system doesn't deliver any justice, and what you need is a community mandate. So we have seen women's organization, tribal organization, in rural areas, they have also organized issue-based Lok Adalat, whether it is about domestic violence or sexual violence or pollution or violation of environmental norms, on forest dwellers' rights. All these things have been done. But one thing is there, like we have also been party to so many public interest litigations in the post-emergency period on behalf of People's Union for Civil Liberties and Committee for Democracy and PUDR, People's Union for Democratic Rights, APCLC, Andhra Pradesh Civil Liberties Committee, People's Self Movement, and Jaina Swasthya Abhiyan. All this you have to do very meticulous research of getting authentic sources from the official documents and macro level data, and also the testimonies of people. See to it that all those who are for whichever cause you are fighting, they don't turn hostile. The so-called very rapport and trust building with the concerned parties is also very important. We saw Swami Agnivesh was himself working with the for the liberation of the bonded labor workers, or Shankar Guhani Yogi ji. He himself had taken part in liberating bonded workers against the extremely barbaric and cruel landlords in Chhattisgarh. At that time, it was called Madhya Pradesh. So when they filed the petition, then there is a popular mandate. It's very important. The same way, petition against harmful contraceptives filed by 6 women's organizations, and later on also by the All India Democratic Women's Organization, because they were working with those women in the bastis who were victim of such contraceptive research. that they could stand the whole aggressive campaign by the drug lobby and by the by the health ministry, which was in a denial mode. Same thing with the PNDT Act. When the PNDT Act was enacted in 1994, it has so many loopholes. It also only criminalized the victim who underwent, say, sex-selective abortion. And the fine was also on the victim. It did not say anything about the medical lobby and the techno-docs. And finally, the petition was filed by Dr. Sabu George, who was a nutritionist, who had gone to the field in Tamil Nadu. He was a professor of MS University, Baroda, who had gone for his field work, and he saw massive cases of female infanticide. And when he probed further, he also came across so many cases of sex-selective abortions in a small town of Tamil Nadu, when he decided to dedicate his life to the cause of girl child. Now, he filed this petition. He was backed with robust research, ground level data of what is happening where. And that made the petition, like after nearly 8 years of struggle, in 2002, we got PCPNDT Act. The same way during the pandemic, all those relief workers who were working in the community, providing food packets or organizing tests or organizing community kitchens, organizing water from the tanker from municipal corporations, they realized that there were so many violations of the people's needs. But there was a massive hunger in the community. Reports after reports talked about malnutrition among children. Even in city like Mumbai, where you never, hunger is not a problem. In Bombay, you get food at every nook and corner, and right from the 10 rupee wala khana to the expensive food, you get all range of food. And this is the first time we heard from everybody, even the skilled workers were reporting massive hunger. Itni bhook humne kabhi nahi dekhi. And when all these reports were collected by Janaswasthya Abhiyan, they filed petition in the Supreme Court in the midst of lockdown. And then a National Human Rights Commission had to appoint a 21-member committee from different parts of the country to address the needs of people within the lockdown, especially the reproductive health needs, because women were delivering on the road, or there were cases of women were not given menstrual pad. None of the reproductive health concerns were considered to be essential service. Maternity wards were converted into COVID ward. So it was very important. The ground level data, as Dr. Shalu Nigam said, is very important. Violation of democratic rights, the massive use of lathi charge and beating up people, vendors and people found on the road or at the time of reverse migration. We saw all those videos, and we had a documentary evidences. We have a pictorial evidences which served as coming up with the code of conduct for the criminal, for the police. And can we call such health emergency? Should health emergency be handled by the healthcare system and the governance structures, or by the police? Because the moment you call curfew, police comes into picture. So should we have declared the lockdown, and all the curfew rules of curfew should have been applied? That is the question human rights organizations are asking. The question of diversion of funds, massively it happens when the Asiad Games took place or when the Commonwealth Games took place. The funds which were earmarked for scheduled caste plan, for the education and health and skill building and for the Dalits, they were diverted for the Commonwealth and the Asiad. And there were public interest litigation filed by Delhi University professor on behalf of PUDR, Prof. Zamia. Then rights of forest dwellers, about which Shalu Nigam ji also sourced, Sandesh Chachara ji has told us in the very first lecture, and how the NTFP, non-timber forest products, which contribute to the tune of 3,000 crores to the GDP. I think forest dwellers should have. So except for timber, all of the products in the forest dwellers are allowed to collect and then sell it to the concerned party, whether it is a trader or a wholesaler or a pharma industries, if there are some pharmaceutical products. The question of Akhil Bharatiya Safai Karmachari Sangathan under they filed public interest litigation about the manual scavenging. The government was in a denial mode. Most of the commissioners of the local self-government bodies in the urban centers, they said, but we don't have manual scavenging. They all were not even accepting. And Safai Karmachari Sangatna gave so many evidences of even Tata Trust and Mahindra Trust. They also commissioned a massive research to collect the evidences of manual scavenging happening throughout the country. And then the municipal corporations and the commissioners, they washed up their hand by saying, we don't do it. It is the private cooperative societies. They are the ones who tell these manual scavengers to just take a drink alcohol and get into the sewage. No? So that is in Bombay, they call it Batli Gayani. Aja means go inside and get drunk and go inside. So then the rules about the housing cooperative societies also are now in making. So it is very important that we as citizens, wherever in our reality, we see whatever the wrong happening. We have seen so many child rights organizations, when they saw the child labor being employed in the domestic work arena, they would use the law, they would file public interest litigation, which would make the authorities to investigate what is the extent of child labor. We know we have this law. But we know and in city like Mumbai, they were in a denial mode that there is a zero child labor. And then the NGOs collected and they showed that how in various pockets in the industrial zones in Dharavi and all, children were working. They were also into the processing of many hazardous industries also. They were there, whether it was a processing of the like tanning and all, where you have to use acid, and they gave that. So it is a very important, and currently we see the environmental movement and the citizens organization are also taking up, they are monitoring pollution level in their own area, and they are reporting. So the citizens journalism or the video volunteers, this whole new movement that have come, they have also played a very important role in providing corroborating facts to support the PIL, and that has worked. But it's a very important session we have had, and I commend the work of Dr. Shalu. Thank you.
Thank you so much, ma'am. And now the floor is open for questions from the audience.
Yes, Dikshita ji, go ahead with your question.
Yes. Ma'am, I have a question regarding the PIL. So you said that
We have lost you, Kumari Dikshita.
the society to get empowered.
Please repeat your question.
Just a second. Yes, ma'am. So sorry for the interruption. So I was saying that PIL has empowered the weaker sections and the common citizens of India, and also has
Again, we have lost the voice.
I think connection issues.
PILs. So still, the challenges remain the same, even if the law are there to empower people and protect people's rights. Challenges still remains the same. So.
We're losing the connection. Dikshita, why not you just type in your question?
Yeah.
In the box here. If any other participant have any question, please raise your hand or type in.
Saujatya Roy, ma'am.
What kind of suggestion can you give in this regard?
There is one more question in the chat box.
So Yeah, if I'm audible, I can go ahead with my question.
Yeah, please do.
Yeah, there is a perception that public interest litigation is often driven by personal agendas or activist groups rather than genuine public interest. How can we ensure that any petitions thereof under that mandate are filed in the true spirit of serving the public?
In fact, that is why we have said that, we have, like, ma'am also said, Vibhuti ma'am has explained that, how the social organizations, they have presented the data, they have gone to the ground, they have conducted research, they have presented the data. So when data and fact is there, it's difficult to deny when you're bringing the facts from the ground, you're bringing the testimonies of people. So then, it's difficult to deny, even for the like in most of the cases, as ma'am has given example that, that the government has denied that there's nothing of the sort is happening in our in our community. But then when you give the data, they cannot deny. When you show the videos, you show the pictures, you bring all kind of testimonies, then how can, it will be difficult for them to deny. And then basically you have to take, a lot of, people like, you're not talking about just one person or two person. And that is what they have, sometimes they have dismissed the petition because it is frivolous. But when you're going with the data, then I think, your case is much more strong. So let the people say that, that, okay, like this is not happening, but then we are giving you the evidence that this is happening in your area. So you have to do something about it. So this is the way I think, over the years, the experiences show that we can do like that. Ma'am, would you like to add?
Yeah, I would like to add that personal is political. Okay, so even when you are harassed for a dowry as a single woman, or a person like, say, Mary Roy, she was not given equal, she was driven out of her ancestral home because Syrian Christian daughters don't have a right to, they did not have, Travancore Christian Act did not give equal right to daughters, and this thing. All the fights about personal laws, right from 1972 to 2023, it starts with the personal tragedy. And then they start, this person, she shares her experience, she writes about it, she fights in the lower courts, and she gives public talks. I remember we have organized talks of Shenar Sheikh and Mary Roy and the Parsi lady who fought against it, Buri Bai, tribal woman, or Dagi Bai. And then the public opinion is created, and so many other women, hundreds of women, they said, oh, this is my life too. So it starts with public, personal tragedy or personal injustice, and then it gets, it's like Gandhiji, who was driven out of a train in South Africa, and it became a big movement of satyagraha against apartheid. Which struggle is not, unless you have a personal stake in the issue, you will not fight it. We also, and women, and everybody tries all other avenues. You go to your local bureaucrat, you go to your local politician, you write petition, you write letter to the editor. Olga Tellis did everything, no? Finally, when no response she got, when she saw, we used to see massive slum clearance in the name of slum clearance. Bulldozers after bulldozers were just ransacking the life. A young engineer from IIT, Colin Gonsalves, I know how he intervened when the police came to just in Bandra with bulldozer, and the way mercilessly they were beaten, because women were always in the front, and he saw elderly women being beaten up this thing, and he intervened, and his photograph appeared in the front page of Times of India. His father threw him out. He was staying in our house, no? And we have seen, so it started with the person getting sensitized or energized or angry, but then it becomes a movement, because that particular episode galvanized people into action. That what's happening in the name of beautification of Mumbai. Anand Patwardhan made a film, Mumbai Hamara Sheher. Some artists, they wrote poetry. So various types of anger and channelization of this anger in terms of building a movement happened. So I think I would go by the feminist slogan, personal is political.
Thank you so much, ma'am. Dr. Nivedita P. Haran, IAS, retired, former Additional Chief Secretary, Government of Kerala. Now I would request ma'am to start a session on bureaucracy, laws, and public policy. Ma'am, welcome and over to you.
Thank you, Shweta. Thank you. Good afternoon to all of you, Professor Patel, Dr. Arjun. Will you do the screen sharing, Shweta? Or should
I will do. Yes, ma'am.
Okay. So I'm happy. I'm happy to be joining here. And what I'm going to be talking about is a bit different from PILs. I want to take you through a public policy process. How does a public policy come into being? How is it conceived? How does it come into being? And finally, what happens to it thereafter? What is important in it? So that is my intention today. Of course, I'll be touching on various aspects of law also. And I'll also be putting in little illustrations from my personal experience. So if we can have the screen sharing, please. Let me start. A public policy is a function of different systems that are in place in the country. There are 5 factors as I see it. The systems in place in that country or that location, the political, the social, the economic. Second, the information and the data that is available. I think the previous speaker also talked about the statistics and the importance of having reliable data. And only when you have reliable data, your policy can be good and you can counteract something that is wrong in the policy or if the policy needs to be amended. Third is the mindset of the government and the governed. The government, of course, is important, but I say governed also here because unless, and I'm going to speak a little more of that later, unless the governed are able to absorb what the policy, the intention of the policy normally is a failure. Fourth, the financial situation in that location, in that state, the region, the country. And finally, the efficiency and the effectiveness of the bureaucracy, of the public service, right from the top to the bottom. So, given the fact that these 5 aspects are the basis of any policy, the entire lifespan of any policy, public policy, why is public policy needed? Now, public policy is needed because public policy is the bedrock of any governance. So we start with the vision and the mission of the government that leads to a policy, many policies, which leads to programs, which leads to projects. Next slide, please. The systems and institutions that I mentioned as the first factor include the physical features, the climate, the people, their way of living, their geographical location, etc., etc. That includes the kind of crops they grow, the kinds of needs they have, what is important for them and what is not, as far as their physical needs are concerned. Second, the social, the anthropological background of that area, the history, their beliefs, their cultural practices. So any act which or any policy that talks about, for instance, the right of forest dwellers would be relevant in a place like India, could be in other places also, but could be relevant in a place like India and in states that have forest dwellers, that have tribal community, and not in other places. So the historical background and the anthropological background is also important. The political, the type of government, is it a democracy or not? The awareness and engagement of the government, you can have a very removed and distant democracy, you can have a very hands-on democracy. How vibrant are the political institutions, and not just the political institutions, but I mean the other institutions, what Professor Patel was mentioning, the activists, the academics, people who are working in the field with the ground at the ground level. That's also important. And finally, the economic status of that place, their GDP, the level of development, is there poverty or there is no poverty in that country? What are the resources available, etc. Next, please. Now, information and data is very, very important for drafting any policy, any public policy. And that, unfortunately, sometimes we don't give much importance to. But as time passes, it's becoming more and more important for two reasons. One, because information is now, data is now more easily available. And second, the government and the public servants have realized that policies that are not based on proper, accurate data is not really enforceable. And that is the reason why information and data is so important. Now, the nature of that information, how easily is it available and how accessible is also very important to be kept in mind. Its relevance, it could be data that is not even relevant. So if you're having a policy on, let's say, the health status of the people living in a certain area, if it's data pertaining to the, let's say, the price of commodities, that is not very relevant. So what is really directly relevant for that policy making, that should be kept in mind. Is the data adequate? Is it balanced? You know, as you know, it's always possible to see data from different perspectives, and data can also be monitored and tampered with. So that is also important. I remember when we were doing the land records digitization in Kerala, the data we found was actually, it did not take into account the entire state. It only focused on those areas where the data was of a certain nature. And when that happens, the policy also gets skewed. Therefore, one has to be careful. The reliability of the data, how recent is the data? Data has to be, it cannot be dated. Its usability, is it usable or is it in a format where it doesn't make any sense? And its acceptability. Now, I talked about the attitude of the government. That is one of the aspects of policy making, and the attitude of the governed. Now, let me take the first. The attitude of the government is very, very important, because by government, I mean not just the bureaucrats, I mean the political executive and the bureaucracy right from the top level to the grassroots level. And every organization that is quasi-government, related to the government, etc., etc. Now, how serious are they? That is that's crucial, because unless a policy has the required seriousness to back it up, that policy is not going to be implementable. It will not be taken seriously when it is to be implemented. How committed is the government? The persons who are going to finally enforce that policy, how committed are they? Are they really serious about implementing it, or is it only to gather votes, for instance? Or is it only to please the people or to please somebody? Or is it only for a specific person, an individual? We have to keep that in mind. How honest are they? I'll talk about honesty and corruption a little later. And the priorities. The priorities have to be right. You know, in an area where you require, or in the COVID situation where what was needed was the health sector, one was not talking about tourism. That is not a priority. So in that manner, one has to make sure that the priorities are in the correct place. Now, I talk about the governed, the attitude of the governed. And I think it is not talked so much about, but it is extremely important. And I say this because coming from Kerala, having served in Kerala much of my life, and now living in Delhi, I see the sea difference, the sea change that has occurred in Kerala because of various reasons, because of literacy, because of more awareness, because of engagement of the people, because of the attitude of the political leaders there. Whereas in UP, in Delhi, the matter is different. So the attitude of the governed is very, very important. How aware are they? Their socioeconomic status, of course, is important, because you can't talk about culture to a hungry man. You have to make sure that their socioeconomic status is of a certain standard, and their involvement. Are they willing to be involved or not? Next, please. The financial situation, the constraints that the government faces, and often you will find that I think many of you and the previous speakers also mentioned, many of the PILs come because it is not because the bureaucracy or the public servants are not wanting to do something, whether it is, the importance of doing away with manual scavenging or etc., etc. It is because of the constraints and the priorities. What are the priorities? The priorities have to be those that are considered by that government, by that country, to be the most important at that point of time. I think that should be very, very clearly understood and laid down. The commitment, the restraints that are there, the restraints come from various interest groups, various lobbies that are functioning all the time, and the other sources from which funding can come. Funding can often come from, as you know, it comes sometimes now from CSR sources, it comes from voluntary donations, it comes from the philanthropic societies, and so on. Now, I want to talk about the fifth aspect of which is important in policy making, which is the implementation part. Now, any policy is as good as its implementation or enforcement. There is no point having an act and then not putting it into practice. We have an act in many states, in fact. It's about protection of SC/STs from selling off their properties, their landed properties. But willy-nilly, they do sell off their properties, and often it goes unnoticed. Why is it so? Is it because there is lack of commitment on the part of the elected representatives? Or is it willfully ignoring this aspect? Because, sometimes, and that attitude is common, it is dangerous, but it is visible that there are people who feel that once you bring an act, you are seen to have done what you needed to do. And thereafter, you don't need to do anything. And that can be very, very dangerous. The professionalism of the bureaucracy is very important. A bureaucrat is there to serve the people, and he or she has to keep that in mind at all times. The efficiency of the bureaucracy. The bureaucrats and the public servants may be very, very committed, but they are not efficient. They don't know how to get the work done. So then that makes them useless. How effective are they? They have to show that what they are doing is leading to results, the quality. It should be that the money spent is actually giving the necessary results. Otherwise, in a country like ours, it doesn't make sense to have policy and then implement it in a manner that doesn't give the best results. The awareness levels and involvement of the beneficiaries is also important. And I mentioned Kerala again because I remember the post-tsunami rehabilitation program, which I was implementing. One of the reasons why we could do a lot of things, including rehabilitating people who were living in dangerous areas on the coastline to areas which were safer, was possible only because the beneficiaries cooperated. Because initially, from the political side, from my colleagues, from everyone, the response was, the fishermen will never move away from the coastal areas. But we found solutions. And what the solutions were, they have to be innovative. They have to take into account the needs of the people who are being impacted. And that's how policies get implemented. And finally, accountability. In accountability, I would consider it is important to make sure that everything is transparent. As much as possible, it is done in a manner that the beneficiaries are aware as to how much of the money is going where. That is extremely important, because unless they know the details of a project, which is being implemented as part of or as a result of a policy, they will not be able to ask the relevant questions. Now, in a nutshell, I have made a small diagram where I want to show you the back-end scenario as to how a policy is born. Now, a policy in most cases, most cases, if not all cases, starts from the manifesto. The government in power has a manifesto which has certain wishes that the government would like to fulfill when they come to power, if they get elected. And once the party gets elected and the government takes over, then that manifesto, the wishes in the manifesto actually become the basis for public policies. There are also pressure groups and interest groups and lobbyists that come in, which come in with ideas and suggestions, which may not be part of the manifesto, but they are also often, they can lead to policy making. Now, once the policy, the basis of a policy has come into being, and then once the public, it comes to the public knowledge that the government is coming up with a policy, for instance, a policy, let's say, of cleanliness, of swachhata, what happens? There are petitions. In present times, there is the social media, the tweets, the emails, the interaction with the public that public servants have with the public, as well as the elected representatives, the media, the questions that come up in parliament, the stand of the opposition. All these are feedback on a policy, on a policy that is yet to be born. Now, once the government drafts the policy, that department which is concerned with drafting the policy, and most often, I think I would say very, very often, any public policy has multi-departmental impact, involvement. And there is an interdepartmental consultation that happens. The paper is circulated, whether it's a white paper or a policy paper, it is circulated to different departments that are concerned, and their remarks taken. It then normally goes to a committee of secretaries of those departments that have given their views, or others who wish to be part of the policy making. If they think even remotely they would be connected with it, and the committee of secretaries then examines the policy and finally finalizes it. Now, while they are doing it, there are occasions, and I can name a few, where the draft policy is outsourced for getting suggestions from others who are not part of the government. And for instance, when recently the government came up with the idea that they would like to have a policy for allowing foreign universities to open campuses within the country, draft policy was floated, and suggestions and objections and ideas from outsiders, from others, was sought for. So that is also done. And that is very often the case. For instance, a land policy of Government of India in Delhi, it normally gets objections and suggestions. It seeks objections and suggestions from outside, from the public in general. After that is done, once one would say that the policy has reached a stage where all the departments have given their ideas, concerned departments, and it finally goes for the approval of the cabinet. Once the cabinet has approved, of course, cabinet approval can take time because it can go up and down. Some minister somewhere may ask a question which may need to be clarified. Then the matter is taken up at the next cabinet or next cabinet. And thereafter, once the cabinet approval has been obtained, the policy has come into being. It has an official and a legal status, which can then not be denied or tampered with by any government. Now, in doing all this, you have to keep in mind that there would be political underpinnings, there would be vested interests, there could be bargaining by groups, pressure groups, and there could also be the presence of corrupt practices. We have seen the case which has come, I'm not sure I can say much about it because it's sub judice, the liquor policy of the government of Delhi. So you see, there could be underhand dealings also, which may not often come to the notice of everyone. Next slide, please. Now, once that happens, once the policy has come into being, the policy need not always be followed by an act, but very often, more often than not, the policy gets a legal backup, because only when the act, it gets the basis of an act, it becomes a legally justiciable policy. Therefore, an act followed by rules and regulations. It could also be a simple guideline. You see, an act need not always be the case. It could be a simple guideline. The policy could have not just a central government, but most of the items that are of day-to-day importance for the common citizens are actually under the governance of the states. So therefore, the central government then has to pass that down to the states, telling them that this act or this policy has come into being, and you are now required to enforce it and implement it. Now, how will it be done? Who will do it? Which level? Whether it will be done by the collector, by the panchayats, by the secretary concerned, that depends on the guidelines that follow on that. Now, it also is important to see whether there are existing systems that are in place to implement that policy. In a country like ours, where we have a very, very elaborate system of governance, most often new policies also they are normally fitted into existing systems, but sometimes it may require a new system to come into place, or a new organization or a new agency to come into being. For instance, when the IBC came, the Insolvency and Bankruptcy Code came, there are requirements in that code, in that act, which required that some new entities come into being. For instance, an information utility that was not existing in our country earlier, but with the act, it came into being. Asset aggregators, these were not there. So you see, sometimes the act requires that some new authorities or new agencies or new departments or new agencies come into being. It could be a single department, or it could be multi-departmental, even at the state level. I mentioned it earlier. At the administrative and financial requirements, who will take care of the administration of it and the finance of it? That, I think, the center state will have to decide on that. It could be part of the act, it could be beyond it. Sometimes it could be 100% the Government of India funded program, or it could be shared between the states and the center, or it could be totally funded by the state governments. Again, prioritization. There are many, many policies at the same time. There are existing policies, a new one has come, which gets priority. I think these are things that the state governments or the implementing agency will have to take care of. And thereafter, once the implementation or the enforcement of the policy has begun, there is need to have a system to review it. By review, I mean how much of that policy has actually been implemented, the requirement of the policy, how much of it has actually been implemented and has actually come into being. That is important. That is the evaluation part. And the impact. Now, with this policy, has it had an impact on the people, on the people's lives? The impact that was anticipated, has it taken place? Or it has just been it's been a dud. Nothing has actually been successfully implemented. Or even with the implementation, the impact has not happened. So that is why the evaluation is very important. And something I'm mentioning here, I've just snuck it in, misinterpretation. Misinterpretation often happens when an act is a central act and it is passed on to the states. And the state very conveniently, maybe either knowingly or unknowingly, misinterprets it. And the act goes in a direction that was totally unintended. Now, I have talked about the requirement of a policy. How does a policy get born, and how does it thereafter get a life of its own? Once a policy has come into being, unless it is withdrawn or unless the law itself has built into it a time frame, the policy is there until withdrawn. It continues forever. So therefore, one has to be careful the kind of policies one is bringing. The policy should not be something that is only for an overnight requirement. It should be something that is required for the country. It is for the betterment of the country. Now, earlier I mentioned about the awareness of beneficiaries, and I want to mention this. And I took the example of the ST and SC Land Alienation Act earlier. I would like to mention another act which was there, which came from the government of India, which the states had implemented, which is the Forest Dwellers Rights Act, FRA, Forest Rights Act. Now, it was an act which was brought in, an extremely important act for our country. And I'm saying this not because I was part of the think tank that was drafting the act, but because I feel that one of the reasons why the forest dwellers and the scheduled tribe community in our country were suffering and were losing their existence in a way was because they didn't have any control over the lands that they were holding. And coupled with that, we had the forest department, which is a very well-defined system in our country, which is a well-defined service in our country, where they are supposed to be protecting the forest lands. Now, there was a constant conflict between the two, and therefore the need for the Forest Rights Act. Now, the Forest Rights Act very, very succinctly and very clearly laid down that who will be the people who will get a right, who will get the right over the land on which they are either residing or their forefathers had resided, and who would get the land rights document. Now, what happened in many states was, one, because and I'm saying this with full knowledge of it and without mincing words, because the forest department was very powerful there, because it was an existing department with a minister, with a complete setup, they felt that the Forest Rights Act was actually undoing the good work that they were doing. Now, it's necessary to make sure that the two came on the same platform, the forest protectors and those who would then be residing in the forest, who in a sense would then be living off the forest and therefore in a sense be, quote unquote, destroying part of it, let's say, cutting some trees, growing crops, etc. So many of the states in their wisdom thought that it's best to just let it lie low. But then the directions had to come from the central government saying that the act is there to be implemented. And of course, the matter went to court, and there were directions from the apex court that the matter should be attended to in a time-bound manner. So you see, it is important to make sure that when an act or a policy comes into being, it does not, in a way, make it, its very birth makes it unimplementable. That is not a good way to start a policy or a program. And that is why the beneficiaries' involvement is very important. In Kerala, one of the ways in which, although the tribal population is actually quite minimal in Kerala, not a very high one, I think it's about 3.5 lakhs. Even then, the pressure from the tribal groups was high. And we had to make sure that we actually implemented the law, not only in letter and spirit, but we went beyond it. We also went beyond it in the sense we issued the record of rights document, not only in the joint name, but we made sure we put the woman's name first. because it's only when it's only the first name that matters in certain cases. So therefore, these were things that we did. We gave them a laminated copy of the document. So these were things that came into being only because the beneficiaries were aware, they were self-confident, they could come and argue. I was the land revenue secretary at that time. And they could also say that if you don't do this, you are actually violating an act and you're actually violating directions of the apex court. You see, that kind of awareness and questioning attitude is needed. The interpretations. I mentioned earlier, the act or the policy could be interpreted in a manner that would be very often in favor of the people who are powerful, and the people who are not so, who are less powerful, get weeded out in the process. So therefore, it should be seen in a manner. It should be seen not only by the beneficiaries, but by people who are working in this area. And I say this especially to the academicians who are listening to me today, that it is important to make sure that the interpretation of the act is done in a manner that is actually in a way that it was intended to be. The GDP or the GNH, we talk about the gross national happiness at present. So that is also important. But I think at present we can limit ourselves to the GDP because and not confuse matter by bringing in happiness factors for the present. Bridging the gaps. I have been often speaking on this. A policy, as I said in the beginning itself, is as good as its implementation. And in our country, unfortunately, many of the policies, quite a few policies, have not been successful because their enforcement or implementation was poor. And I again go back to the manual scavenging. It was actually through an act made illegal many years back, even before I entered the service, and yet it continued. It continued because there was a gap between the policy and the implementation part of it. There's also a major gap between the politics and administration. I think that is a gap, again, that needs to be ensured that that gap does not exist when a policy is being implemented. There is a gap between researchers and field workers, and I find this more and more these days because I'm more into academics than in bureaucracy. I think the academics are doing yeoman service in bringing out the faults, the fault lines, the disadvantages, the shortcomings that are existing in many of the implemented policies. But, and I say this with perfect confidence, I think a lot of them happen because there is a gap between how the researcher looks at it and how the field worker or the bureaucrat or the public servant or the secretary of the panchayat or the tahsildar or even the district collector looks at it. I think one has to understand that before one says that they did not do it or blame anyone. I think a lot of these things could be much better implemented in our country if only we did it with an attitude of not finding fault, but making sure that the act actually gets enforced. And that very often does not happen. And then there is the gap between the people who think and the doers. You know, it's always possible to find a fault with anything that is done, but it is also important to make sure that some things are done, because without it, I don't think we can make this a better place. And then I would like to mention very briefly the quality and the attitude of the bureaucracy, of the bureaucrats. I think a lot of people have a lot of blame has been put on the bureaucrats, and rightly so. I think there is need for what I often say, not just efficiency and effectiveness, but also empathy. And that empathy often in a bureaucrat is lacking. And I'm not talking about just the senior bureaucrats, I'm talking about every level. And I think more than a secretary sitting in the secretariat. I think the more important person is the district collector or the tahsildar who is sitting in the field. The empathy amongst them is very important, and that comes only through constant badgering, asking questions, making sure that they are doing the right thing. You see, you can only train a person so much. The bureaucrats, all bureaucrats at every level get trained. But empathy is something that you cannot train. You cannot put into a person. You cannot spoon feed. It has to come from within. And there are people who are empathetic, who are part of bureaucracy, who are outside bureaucracy, who are academics. And in the same way, there are people who lack empathy, who are part of the academics and part of bureaucracy. So we have both kinds of people in all sectors. What we need is we need more and more people to imbibe empathy who are part of the public service. This is important because it is only when that happens that a district collector sitting in the district headquarters realizes that when a laborer starts walking from his district to go to his home state or home village, it is something that his labor officer has to attend to. He cannot allow that to happen. If there is, if the maternity ward has been taken over because of COVID, he has to make sure, the district collector has to make sure that there are alternate arrangements. You see, that is empathy. That is being able to think on your feet and make sure that the people's interest is protected. And with this also comes the need to be aware of the pitfalls. And the biggest pitfall in our country, unfortunately, has been what I say is, the system of graft and corruption. I think here modern technology has a very important role to play. Of course, making things aware through the social media is important, but also making sure that financial dealings happen only through bank transactions or through online transactions or through the other means of transactions without going into cash handling. I think that is one of the biggest ways most important ways in which we can reduce corruption. And the second way is to reduce the interaction between the public servants and the citizens, the common citizens. And I give this example very often. I have come across a case where a person who's actually a big man in that area goes into a village office and gets an income certificate in no time. Within 5 minutes, he comes out with an income certificate because he's known to everyone. Whereas a poor villager, a poor grandmother who needs the income certificate to send her granddaughter to a nursing college in Bangalore, she has to come back 3 times, 4 times. Why? Because she's not well known there. Now, that is where I think that public interaction takes over. And more it gets possible to do things online. I think this kind of discrimination between the haves and the have-nots would be reduced. What I call the digital inequity that has somehow come into being in our country now, and it's normal because a poor person's son does not have a laptop to attend classes on Zoom, whereas a person who's better off has a laptop or a smartphone. So you see, that kind of digital inequality has to be also taken care of. And it is the responsibility of the bureaucrats to make sure that that kind of inequality doesn't flourish. And I was so happy to see in a place recently in UP, and I had been suggesting that for some time, in a village, the local RDO there, the revenue division officer, had actually set up a small computer center where there were 20 laptops, and he was making sure that every child who needed to attend classes through Zoom or who needed to do research work for doing a project could book time, go to that place and use the laptop because he doesn't have a laptop at home. You see, this kind of innovation, this kind of novelty can come when the bureaucrat thinks in a empathetic manner, but it can also come when the private sector thinks in an empathetic manner. And there is nothing stopping them from doing so. There are a lot of good practices that have taken place in our country, which can be very well replicated in many, many places. I think I have come to the end of my presentation, and these are a few of the recommended readings. Professor, if you have anything to add, please go ahead and do so. Thank you.
Thank you so much, ma'am, for the enlightening session. It was truly inspiring, and I'm sure that it has empowered every one of us here with a deeper understanding of the interplay between bureaucracy and public policy. Thank you so much, ma'am. And now I would request the chair, Professor Vibhuti, ma'am, to share her remarks.
Thank you, Dr. Nivedita Haran, for explaining all the processes involved in the policy making and the vision, mission, programs, and how the structures and mechanisms are created and the rules and regulations become very important. My first thing is about the data fudging. We have always seen whether it is in the Finance Commission believes in equalization of the resources of different states. Horizontal equality and vertical equality it talks of. So what we see is that at the when it comes to budgetary allocation, most of the states and union territories, they inflate the data of below poverty line population. But at the same time, in the electoral speeches, what we see is that they show that how they have reduced poverty. So that gap, I think, is a very important thing which we are seeing. Second one is that when it comes to gender responsive budgeting, which India adopted in 2005, but even after like 15 years or 17 years, we see only half of the states and union territories implementing it. So I think you're thinking about the role of administrative staff college, training of the bureaucrats and the actual people in the Mantralaya and Secretariat become very important. Third one is that question use of communication versus force. You gave an example of Kerala versus UP. So I think whenever things are communicated to people using various communication media and also in local language, then you don't have to use force. I think that we also understood from the experiences of pandemic, no? How different states dealt with wherever the politicians, local self-government bodies, or even the media was very active in terms of communicating everyday new rules that were coming up, no? About various facilities and this. Then the response, people, there was a less use of very brutal force by the police. And fourth one is that the term called beneficiary. Currently, the discourse is that do we call them beneficiary? Because everybody pays tax. Indirect tax is paid even by the beggar or people unemployed. So can't we call them stakeholder instead of, because when the moment we use the term beneficiary, it becomes the paternalism of the state. So these are my but it was a brilliant presentation. I really learned a lot.
Thank you. Yeah, starting from the last, yeah, that's a nomenclature, Professor.
Yeah.
I think, yes, but you know, it's beneficiaries, it could be stakeholders, it could be the clients, different things, different words, terminologies are used. But you know, it's everyone is a beneficiary in a way. Just as everyone is a contributor, everyone is a beneficiary in a way. We are benefiting from the roads that government constructs from the water supply, electricity, etc. So I personally, I don't have any objection to that word. Training, yes, very, very important. But you know, I have found from my personal experience and having attended many in-service training, many my induction training, and now as a trainer, I think in modern times, when data availability is so easy, information availability is so easy, I think what we need to primarily do in training is to give them a hands-on experience of how to handle cases. And I think that really has a much more, I would say, solid impact on the trainees, rather than, making them sit down and teaching them the Constitution or case laws, etc., which they read up anyway. They can be asked to read up, but they should be able to try a case. A Section 130 case or a maintenance case, then it is only then that they realize what is it that they need to do. And therefore, it goes without saying, and that applies not only to the bureaucrats, but to all sections of society who have to undergo who are required to undergo training. You mentioned about data. Yeah, data is, it is possible to look at data in different manner and also manipulate data, as you said. And that is why I think again and again, I come back to the point of awareness. Awareness, not just amongst the citizens or the beneficiaries, quote unquote, the clients or the stakeholders, but the awareness of even the academics, the researchers, and I'm saying this without sounding as if I'm showing disdain, but I have seen research papers which have been written without even understanding the basics of some policy, for instance. So you see, one has to make sure that the understanding is correct. And I think people like you who are teaching our young minds are probably doing one of the most important service in that manner. And I think the fact that you make sure that the research is in an area which is actually relevant for the country, for the people, it actually is something that is not repetitive, I think that makes a lot of difference. That brings about good quality research. And I go to the extent of saying, when I deal with the researchers, that make sure that if it has a public angle to it, make sure you share it with the people who are concerned. Send it to the secretary to the government of India or to the state where the research is based. Because who knows, they could benefit from it rather than keeping it in a library, because that would not really benefit the people who actually are working in the field. So data is extremely important, but as you rightly said, we have to look at data and statistics in a different manner now than what we did when I entered service 30, 35 years ago. Thank you.
Thank you, ma'am. Moving forward, I would also request Advocate Dr. Shalu Nigam, ma'am, to share her remarks.
Yeah, no, it's a very wonderful presentation, and I've learned a lot about, because as a researcher, as a lawyer, we are into that kind of arena, and we have not considered the other side of, the bureaucratic angle which ma'am has shared with us. So surely it is a kind of a different perspective. But just one thing I would like to add, ma'am, because when we are dealing with some of the government officers, some of the judges, some of the lawyers, we talk about generally there is a lack of gender sensitization, and that is something I think I don't know, we are like civil society, a lot of NGOs are doing a lot of gender sensitization programs. But how to indulge that into, because when somebody is implementing policies, say at the panchayat level or at the local level, that kind of sensitivity should be there. You talked about the case of that old lady and that case, but then there should be a kind of sensitization with technology. Maybe the things may change, but still there is, I think, something needs to be done, and that I would like to know from you, what could be done.
Yes, thanks, Advocate Shalu. You're right. This is something that two points you mentioned. One is the change in attitude of the civil servants. I have found some of the most unlikely entrants to the civil service, when I meet them as trainees at Missouri, some of the most unlikely ones who have come from a background which I would never have expected them to show empathy, actually indicate that they have empathy. Whereas some of them who should have had, you know, a person who has been brought up in the villages, he or she herself has been has faced the you know, the wrath of the bureaucrats at some point of time. He or she does not. So you see, it is something that is inbuilt. And that is why I believe, and I share my views with the persons in UPSC also, that I think a selection process should lay more emphasis on whether the person has empathy or not, is capable of having empathy or not. I think that is important. That is, I think, something that probably not everyone is capable of having. And that is really, really important. And the second aspect you mentioned about gender, Dr. Shalu, I have to share with you, of course, I have done a lot of inquiries in such gender-related cases. And I was in the UN for a while, and I found that some of the cases I had to deal with there were not only more severe and serious, but more prone to getting sidelined or put under the carpet, you know. And that's in an organization where the first world, so-called first world developed countries are holding most of the positions there. So you see, I think that's something I have come to the conclusion. That's something innate to human nature. And one has to make sure that we tackle it in a multi-pronged manner. We make the people, the women aware of their rights and responsibilities. We make them aware of the hazards, which is very important. I believe every girl in school should be taught what are the hazards that she could be facing. That is very important. And the third is, we of course try to make sure that the other side, the men folk or the non-women, are also aware of what their role and responsibility is. Now, where the danger comes from, one never knows. And therefore, one has to teach our youngsters. They should keep their eyes and ears open all the time. I think that is the best way to handle gender issues. I find that we have had so many statutes, you will know it better than me, for protecting the women. Despite that, we have the cases, any number of cases happening in the offices of our, in the government, of harassment of women. So I think the best way to fight it is to make the women, the people who are actually being impacted by it, aware of it and fight it. That's most important.
Thank you, ma'am. The floor is now open for questions from the audience.
Mr. Mohammed has raised his hand.
Yes, Mohammed ji, go on.
Ma'am, he's also shared his question on the chat box in case he has connectivity issues.
You can read it.
Yes, I'll do that. Influence of existing corrupt practices. In some bureaucratic cultures, corruption may be deeply entrenched, creating a normative environment where corrupt practices are normalized and expected. Young bureaucrats entering such environments may find it challenging to resist or challenge these existing practices. How do we create resistance to such temptation?
First and foremost, may I?
Yes, ma'am. Yes.
Okay. First and foremost, I keep saying this, is that we must all understand that a person entering the public service is actually entering into serving the people. Don't make them feel as if they are in something where they are, you know, something, the chosen, the chosen ones. They are not. They are there to serve the people. They are not there to get a red light over their cars. They are not there to have 20 people to serve them. They are not there to enable them to enter places without standing in queues. That's not what they are there for. I think that is the understanding that should be drilled into all our public servants, everyone. That is one of the first things that should happen. And then second comes the point that you mentioned, Mr. Mohammed, which is that if taking graft or indulging in corrupt practice is a part of that, the social system, I think there have to be very strong measures taken to make it first, strongly punishable, and second, it should be something that a person should not be able to get away with. Often what happens is that people do it and then they say, okay, it was something very small. No, nothing can be small in a corrupt practice. Even taking 5 rupees bribe is a crime, and therefore one has to take it seriously. I think that is a very important thing. And of course, third, which I go back to again and again, is for every bribe taker, there's a bribe giver. And I give this example, I say that, and there's not much time to go into it in more detail, but you do it with facts and figures. When there was a Bofors on this side, there was a Bofors company sitting in Sweden, one of the countries which is supposed to be most crime-free and corruption-free, giving bribes here. So you see, that just as we are tackling the bribe taker, let us tackle the bribe givers also. And that is you and I.
Yeah.
Yes, Shweta, any more? I think you're on mute.
Ma'am, am I audible?
Yeah.
I don't think there are any questions.
Okay. Yeah, it's lunchtime also for everyone.
Yeah.
Thank you so much. It was such a pleasure having Professor Vibhuti chairing the session.
I also thoroughly enjoyed it.
Thank
So
you.
many learnings are there. And yeah.
Thank you, ma'am. Now I request the chair, Professor Vibhuti ma'am, to share her closing remarks.
I think both the presentations were extremely lucid and with so many case studies and examples of what's happening in the contemporary India, and there are so many learnings for all of us. I think finally it also, you can sum up by saying that both the state and non-state actors, government and the people, all of them have to act in a very responsible way. Constitution is the touchstone. We have laws and policies in place, and when it comes to implementation, the leaking pipeline has to be taken care of. Corrupt practices have to be care of. Communication with the masses and respect for civil liberties and the democratic rights of people, they are also very important. I have really found today's session extremely inspiring, and there were so many takeaways of this session. I commend both Dr. Shalu Nigam and Dr. Nivedita Haran. Thank you very much. It's always I'm listening to you for the second time. Extremely.
Thank you. Thank you very much.
Thank you.
Thank you, ma'am. With the chair's permission, we can go for the vote of
Please,
thanks.
the vote of thanks, yes.
As we come to the end of day 5 of Law and Public Policy Youth Fellowship Program, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course and internship program, I, Shweta Shankar, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our expert for the day 5 session, Advocate Dr. Shalu Nigam and Dr. Nivedita P. Haran, for taking out their valuable time and giving us an opportunity to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel, and lead advisor, Advocate Dr. Shalu Nigam, for convening the session. We thank all of our participants who have raised pertinent questions and actively participated in today's deliberation. We look forward to welcoming you this Friday, that is 23rd June at 11:30 a.m. for our 6th day of the certification course by distinguished experts, Shri Bhartendra Singh Baswan and Advocate Dr. Shalu Nigam. We are grateful if you are watching us later on YouTube or listening us listening to us on our various podcasts or reading our publications. We hope you continue to join in future to our IMPRI, #Web Policy Talk and #Web Policy Learning. Wishing you a good day. Thank you.
Thank you, everyone.